I'm Michael Ohayon.
Hi, I'm Anush Salaniwal, and we'll be the host for today's podcast.
Welcome back. For those who don't know, the Scripps Ranch Professional Career Exploration Club is an organization dedicated to interviewing professionals from many different career paths. We aim to help students find a career that's right for them.
And we have a very special guest today. Give a warm welcome to Mark Angert. Mr. Angert is a partner with the Solomon Ward Steinworm and Smith LLP. He studied law at UCSD undergrad and USD Law. He is an attorney with a focus on business and healthcare. Mr. Angert, welcome to the show.
My pleasure to be here.
So what made you switch from neuroscience to law?
Well, initially when I was your age, my parents pushed me to be a doctor. So, going to UCSD, they were number one in the United States for neuroscience and mammalian physiology. They accepted me on the full scholarship. So I had the opportunity to go and learn, and have this great experience. But as I was getting ready to go to take tests for medical school, and I did take those tests, I wasn't really sure that I was prepared to commit the next 4 or more likely 8 years of my life to becoming a doctor. So in order to make sure that that's something that I really wanted to do, I took a year off and moved to New York and got a job in an international trading company because I wasn't really 100% committed to becoming a doctor. And to me, it was very important, and I recommend to all of your listeners and to you, before you select a career, don't follow your path that was laid out by your parents. Of course, your parents, will give you great advice and want the best for you, but you really need to choose what is best for you and what you really enjoy doing. Because if you choose something that you don't enjoy, well, ultimately you'll be miserable for the rest of your life. And that's something that I really wanted to avoid. And when I moved to New York and got a job in international trading, I ended up developing my own company and spun off the company from where I was working and became a pretty successful businessman. I had an international trading company and a coffee manufacturing company, which manufactured and sold coffee all over the world, and including the United States. And by developing the company, by growing that company, and by negotiating various contracts, various deals, I really got interested in law. To the point where my attorneys that were working for me basically said, go home. This is why you hired us to do this for you. But I was really, really interested in doing that. And that kind of got me to join law school, to go to law school and ultimately become an attorney.
So what are some key differences between personal and corporate lawsuits?
So personal lawsuits are, personal, an individual is being sued or is suing someone. Corporate lawsuits are when you represent corporations or legal entities like LLCs. Ultimately, it depends on the individual and depends on the company. Obviously, if you're representing, a Fortune 500 company, it's not taken as personal when they're suing someone or if they're being sued. You're basically, you have a contact person from a law firm, from a corporation who provides you the information, who you deal with. Mainly it's either their legal in-house counsel or somebody, more higher up with someone who has been personally involved, depending on the lawsuit itself. When a person is being sued, it's much more personal because one, they take it personally that they're being accused of something, or they're suing because they were wrong. So there's a lot of emotion that's involved, and they're paying your fees out of pocket. So there's also, for every conversation that you have, for every dollar that you spend, they have to come out of pocket for that. It tends to be, corporate litigation. So I do business law. I set up corporations, I maintain corporations, I negotiate their contracts, and I do litigation, which is pretty rare because most of the attorneys either choose one or the other, transactional or litigation. Transactional is when it's more of a collegial environment because ultimately the goal is to make a deal happen, whereas litigation is adversary by its nature. You start by being accused or accusing someone. So of course it puts either you or them on the defensive. But I like both because to me, I never want to do the same thing over and over again. And when you do litigation, you get to learn a lot of different topics and about a lot of different industries. Because let's say one of my lawsuits was a $200 million dispute over chemotherapy cancer drug patents. So I had to become a mini expert in that area. Then there was completely something different where my client owned a bunch of 18-wheeler trucks, and there was a problem with the engine, and it cost them $800,000 worth of damage. So when we were suing the people that sold us those trucks, I had to become a mini expert into engines. Same thing, I defended a National Institute of New Zealand who tried to grow specific fruit. But given the environment that was different from New Zealand to California, the fruit didn't really materialize into the perfect shape that it needed to be. And the lawsuit was over $48 million. So all these, when I litigate, I have to become a mini expert in all those kind of fields. So that's very interesting to that.
So when you're looking for a new partner or a team member, what are the characteristics you look for in them?
So again, it depends on the law firm. Our law firm has been in business for over 40 years. And we at Salaniwal have basically made a conscious decision to remain a San Diego law firm. What does that mean? It means that we represent companies and individuals around the world. I have clients in China, Europe, Russia, Ukraine, Germany, everywhere. Like I thought, New Zealand even. But we have one office and we stay in that office. So given the fact that we kind of don't want to grow outside of that office, we are very selective and very picky about who we bring on as partners. First and the most important thing is the quality of work that individual can provide. Because we're very, very guarded of our reputation. It is very hard to get a good reputation. It's very easy to destroy it. A lot of people, tend to grab whatever comes in through the front door just because to generate more billable hours, to generate more fees. But we are very selective about what kind of partner we bring in, just like we are what kind of clients we bring in. So the first most important thing is the quality of work. Second, how well will that person match with the other partners and with the entire law firm? Third, will they be able to handle a case independently? And fourth, of course, we want them to be an entrepreneur, to be able to develop business, to be able to add to the growth of the company, and not just sustain themselves and keep themselves busy, but also provide information and knowledge to other other associates that work for us, who we hope to become partners later on. And finally, it's also important how are they different from what we already have something.
So
for attorneys that one more thing is what will they add to the partnership overall? Do they have some sort of specific field that we don't have already in our law firm that our clients may benefit? Like, for instance, if we don't have an immigration law attorney and we find somebody who is great, of course, if he fits or she fits into our overall scheme, that would be a great addition.
So what does practicing law look outside of the courtroom?
It's not as exciting as you see on television, that's for sure. There's no blowouts. There's no fighting for the better office or things like that. I mean, it might happen sometimes. A lot of practice of law is based on reading and writing. Whatever you do, either transactional or litigation, you have to do a lot of reading and writing. So if that's something that you don't like, and granted, when I was your age, I did not like reading. I was forced to read by my parents. But later on, I kind of got a better taste for it. Let's say that. There's a lot of motion writing. It's in litigation field. There's a lot of motion writing. So if there's a dispute, there's a litigation. In order to get all the information from the other side, you have to propound to them discovery, meaning a bunch of questions, and then the other side has to answer those questions and provide you with whatever documents they have to support their theory of the case, or any kind of anything that you ask them to provide. Most of the time, it's not something that you want to see, or they don't do it a full job or a complete job. So you have to file a motion with the court. The other side has to file an opposition, and then you file a reply. So there's a lot of writing and research to support your position. What else is, there's outside of the court, there's depositions where you basically swear an individual under oath and you ask them questions, and they respond to provide you whatever. You do a lot of fact and evidence gathering in order to be prepared for trial. And in fact, unless you do criminal law, it's very rare that you actually go to court, because with the cases that I handle, they're very high exposure cases. There's a lot of money at stake. And to go to trial is very expensive. To prepare for trial is very expensive. To conduct a trial is very expensive. To bring all the witnesses in, to have the experts in, that's a huge expense. That's why 97% of all cases that are filed end up being settling. They settle because, first of all, you don't want to take a chance to see how a jury of 12 unknown people will react. How will they perceive the case? Will they understand the case? And will they rule in your favor? So you try, by settling, keep it kind of in your hands. Try to control that. But there's a lot of fact gathering and a lot of things you try to obtain in order to ultimately prevail at trial if you have to go there.
So how did you prepare to pass the bar? Because it's a very difficult exam, and very few people end up passing it every year. So how did you prepare?
So of course, I went to law school. So for 4 years, tries to prepare you for that. They give you the basic knowledge and give you the reasoning that you need to use in order to argue one way or the other. Then I took a course called Bar Brief, which was, I believe, a 2 or 3 month course, which condensed 4 years of law school into 3 months. So they gave you like bullet points and great information in order to train you how to take the test. And personally, for 3 months, I locked myself in the house. During those 3 months, I left only 3 times. It was once to attend a wedding of family member, to celebrate my graduation from law school, and to celebrate my birthday. Otherwise, from May, the test was in September. Law school was over in May. From May until September. I'm sorry. The test was, I think, July. So from May to July, I basically stayed home for 3 months, and all I did was practice. I think if you take practice tests, which is very hard to do, it's easier to sit there and review. And my son is now getting ready to take SATs and PSATs, and I tell him the best thing to do is to practice. The more practice you take, the more of a stamina you build up, and that way your brain is able to function and continue to function for a long period of time. And because you're already prepared and you are used to being in that specific situation, that time frame. So a lot of studying, a lot of basically, getting no fun. But I knew that if I needed to pass the first time, because I already had a job as an attorney, so I needed that. And I got married, and my wife was about to give birth, so I knew that if I didn't pass the first time, it would be much harder to get free time to study for the second try.
So what techniques do you use to influence a jury?
Yeah, all right. To influence a jury. Well, so our system is built on the premise that you should be tried by your peers. So if you, being 15 or 16, would have to now go to your class and convince them to do something to support you, what would you do? What I do is, first of all, I try to establish credibility. The most important thing is for you to be believed, and not even you. When a lot of people presume that all attorneys are liars or we're all crooks. There are some. I try not to perpetuate that stereotype. So the most important thing that I do when I prepare my clients to testify at trial is to prepare them and to make sure that they are familiar with the type of questions they might be asked. They know the information pretty well. They don't sound rehearsed or kind of sitting there regurgitating the answers. And they have to be reasonable, because if they're reasonable, then they will be believed. At my most recent trial, which lasted for 2 weeks, we won, and the jury actually awarded me, my client, $500,000 more than what I asked, which is almost unheard of, because they hated the opposing side so much, because their main principal, their owner of the company, came off so bad. She came off as a complete liar, to the point where the judge during trial had to excuse the jury and basically screamed at her outside of the jury, saying, "I know that what you're doing, you're not answering the questions. I don't like what you're doing. Stop doing that." Now, of course, the jury didn't hear that, but when they came back, they're all reasonable people. We're all reasonable people. They may not know the law, and that's a good attorney's job, is to explain it to the jury in a simple, concise way so they can follow and understand it. But they see, if I ask you, "How are you?" and you say, "Oh no, on Tuesday I wasn't there," they'll notice that you're nervous. They'll notice that you're trying to be deceitful, and that means you have something to hide. And once you lose credibility with the jury, no matter how good the facts are in your favor, they will most likely not believe you, and you will end up losing. So the most important part is not manipulating the jury. It's just showing them, here are the facts. Even if your client is in the wrong, if he or she has a reason to be in the wrong, you can still win, because you can show, listen, yes, I had to run the red light because my wife was giving birth in the car. So I ran the red light. It was either that or having a risk my child dying in the car. Or, my son was bleeding and I had to take him to the emergency room. So that's just a simple way, a simple example. And also, I think if you try to speak over the jury, meaning use too much, very complicated words or legalese, they just may not understand you. So I take very complicated cases and I try to break them down to the most essential, most basic things to make sure that the jury understands it. I've had jury fall asleep during trial, which is, obviously not something that you want to see. But what are you going to do? I actually had to clap to wake her up. But when I took, it was a case about a fire that was started in the warehouse, and my client was being blamed for starting that fire. So to show that he didn't do it, that he wasn't there, there was a lot of different factors that went into it. But in order to simplify it, I basically took out a matchbox, and I said, "This is a matchbox. Just because it has matches in it doesn't mean that it starts a fire." Then I opened the matchbox and I said, in order to start a fire, first of all, I have to open it, 1. Then I have to take out a match, 2. Then I have to strike the match against the box, 3. Only that starts a fire. So just because my guy was being accused, you still have to prove the fact that he did all these steps in order to cause the fire. And that the juries understood that, whereas they couldn't understand the chemical reaction that was in play and things like that. And ended up winning because they understood that you can't jump from A to Z without going through the rest of the alphabet.
So when do you recommend that an attorney applies for judgeship, if you do at all?
It's a personal choice. I would not want to be a judge. So I don't know if I'm the right person to answer that question. You definitely have to have significant experience in order to be a judge, not just so that you are admitted to be a judge, but so that you are respected by your colleagues, and so that you have enough experience in order to kind of immerse yourself with the case. Being a judge is very hard, and I'm always amazed of people who do become judges. There are some very, very smart judges in San Diego, and I was fortunate enough to deal with some very smart judges. Some not so smart, and I'm wondering why are they there. But most of them are amazing, and I see how smart they are, and I'm always in awe. The trial that I told you about, where the judge actually excused the jury, he was so smart and so amazing that I could see that before we even opened our mouth, either myself or opposing counsel, he already knew what we were going to say. He already knew where we were going with this, and he already knew the problems with our statements. So I think it's a personal choice. You have to have a lot of patience. You have to have a lot of tolerance. You have to be very, very smart. And I don't think you're doing it for the money. I think, it's a way to give back, and it's a way to serve the community, because I think a lot of them would make a lot more money in private world.
So how has COVID-19 affected the field?
Well, it brought us all online. I think it changed. Initially all the courts were closed, and till this day, I don't think you can show up in court unless it's a criminal matter or there's some sort of emergency. Everything is done online, which honestly, I got to say that I've enjoyed it more because first of all, it makes the day more efficient. Like if I have to appear in court, I have to go to court or I have to drive to court. Here, you dial in or you logged in and you're there. And while being in the comfort of your office or your home. It's definitely taken some toll on the individual, because the biggest impact in my firm, I would say, is that I like being in the office and I like being around my colleagues, and I like being able to talk to associates that work with me in person, and I like to be able to walk down the hall and ask my partners for advice and to share with them the situation that I'm dealing with. This is, of course, much harder with COVID, where we're all remote. But otherwise, I think most of the law firms, at least our law firm, is all virtual. We have all the documents stored online where we can retrieve everything and anything. All the research is done, remotely through web-based programs. The courts and the trials have been delayed, of course, because if you want to get a jury and you can't, have more than 10 people in one place, then obviously you can't get a jury. But I think the courts are now ramping back up and dealing with the situation. So it took everyone for a surprise, but I don't think that it affected our field any more than it did, others.
So give us an elevator pitch on why people should become lawyers.
Elevator pitch. As someone who was pre-med, as someone who was a businessman, I think that, especially in the United States, being an attorney is the best job you can have. And I'll tell you why. First of all, people automatically assume that you know more than they do. Two, people are not going to screw with you because they assume that you know the law, and they assume that you know your rights. Three, people think automatically that you're smart. And four, you really don't need anything in order to do your job besides having clients. If you're a doctor, you need to have some sort of tools. You need to have a surgical, office. You need to have medicine. If you are an engineer, you need to have a drafting board. You need to have tools to draft. You need to have paper. If you are, any agent, if you're a plumber, you need, equipment. As an attorney, most and foremost, people come to you for advice. And based on your knowledge, your experience, and your foresight, you can provide your services. Basically, all you need is your brain. I can be sitting right now in Hawaii on the beach and writing a motion or thinking about a defense or creating a strategy for my case and doing my job. I can be stuck in traffic and I'm thinking about how do I prepare this witness or what kind of arguments do I want to present to the jury. In fact, the best times that an idea pops into my head is when I'm not working, when I'm showering or if I'm sleeping. Sometimes when I go to trial, I have a notepad next to my bed because as soon as I try to fall asleep, some brilliant idea pops in, and I know that if I don't write it down, I'm going to forget it in the morning. So I think now, especially as machines take over, as more of a technology, as technology develops, a lot of careers, a lot of job fields are going to become obsolete. I think no machine can replace an attorney because a machine would be only able to analyze and come up with the best results. But if you are arguing for your client, if you are representing your client, you can't just go for the best result because the best result might be the fact that they will lose. You need to do something in order to limit their exposure or to increase all of their benefits. And I think that going halfway is not something that a machine would be able to do. So I think it's a long elevator pitch, maybe for a high-rise building, not a 3-story building. But that's my pitch.
Well, we appreciate it, Mr. Angert. This was a very insightful interview, and you shared some very perceptive advice about your career. We hope everyone learned as much as we did, and a huge thank you to Mr. Angert for joining us today. We are SRPCEC, and we hope you enjoyed. Bye-bye.
My pleasure. Have a good one.
Bye-bye.